You think that a will protects your family when you pass away, but here's the cold truth. It does the exact opposite. A will virtually guarantees that your family's entire inheritance, including your family home, is going to get tied up in the probate courts, and everything is going to be public record during that process. I'm going to show you exactly how to set up a private, court-free, revocable trust so that when you pass away, everything remains private and no one can see what your family is inheriting. We'll cover the 4 non-negotiable elements that you need, the one mistake that most people make, and then the simple form that you'll need to give to your bank when you set everything up. So let's start with the nightmare scenario, the consequences of only having a will. When you only have a will, it forces your assets to go through the probate process. Your family will not be able to access bank accounts or sell property until they have permission during the probate process, which could be 9 to 18 months. And that means that your mortgage, your bills, and your insurance premiums are going to start piling up. Imagine that your surviving spouse is financially strapped and they need to sell the house that you guys lived in, but they don't have the ability to because the courts will not give them permission. And on top of that, every asset and transaction that you have becomes public record through the probate process. And the average cost for probate when you hire an attorney to help them through the probate process is going to be $10,000 to $15,000, and that's money that could have gone down to your family when they need it the most. If you want to keep your affairs private so no one can see what assets you have and who those assets are going to, and you want to make it easier and cheaper on your family, then a will is going to be the opposite of what you need. The good news is that you can avoid the public and costly probate process. You can set up a trust yourself, but there is a critical warning that you need to be aware of. This guide is only for revocable trust, which will allow your assets to avoid the probate process. It's not going to be for irrevocable trust, which will give your assets asset protection from things like Medicaid, divorce settlements, lawsuits, or creditors coming after your assets when you pass away. If you want help setting up asset protection, you would need to talk to an estate planning attorney that would help you with that because it's a more complex structure. If you want to keep your home, your bank accounts, and your investments out of the probate process, the revocable trust is perfect, and you can do it yourself or you can hire an attorney to do it for you. Don't let court fees and probate attorney costs wipe out your family's inheritance. If you want help setting up a revocable trust so that all of your assets will remain private and avoid the probate process, click the link in the bio, fill out the form, and schedule a time to talk to someone on our team. Now let's drill down. Your trust document is only going to be valid if it has these 4 elements. You will have to create a written trust agreement, and this trust document must clearly outline these 4 things. The first one is going to be intent. You have to clearly write that you are creating the trust document for the state that you live in, and it has to be written down on the document and signed. The second one is going to be a trustee and a successor trustee. So the trustee is going to be the person that manages the assets inside of that trust, and then the successor trustee is going to be the person that takes over the management and distribution of those assets when you pass away. And then the third one is going to be the trust assets. So these are going to be assets you're putting inside of the revocable trust so that they can avoid the probate process. And then the fourth one is going to be the beneficiaries of those assets. So this is going to be who those assets are going to, which assets are going to them, and how much of each of those assets are going between the beneficiaries. Even if one of these elements are missing, the revocable trust will fail and your assets will still have to go through the probate process. Okay, once you have created that trust document, you've printed off and you've signed it in front of notary and witnesses per your local state laws, you still have 3 steps that you have to do to make it valid. The first one is going to be getting it signed and notarized per your local state laws. Now, not all states will require you to notarize your trust document, but it's a good idea to go ahead and sign and notarize in front of 2 witnesses. That way it's a valid document and reduces the chances of someone being able to contest that document down the road. Once you have it signed and notarized per your local state laws, you want to make copies of it, and then you want to keep the original document in a safe place. That could be like a safe in your home, but you want to make sure that the successor trustee has access to that original trust document. Now, you can give the copies to the beneficiaries of that trust agreement if you want to, but you do not have to. The only thing that is required is that the backup trustees have access to that original document so that when you pass away or you become incapacitated, they can find those documents and use them to take over the management and distribution of those assets. The second one is going to be creating a certification of trust. This is going to be a 1-page summary of your trust agreement instead of having to lug around the entire trust package. Banks, brokers, and title companies do not want your 30-page trust document. They just want a 1-page summary that outlines everything that's going on with it, which is going to be called the certification of trust. This is simply going to state the trust name, the trustee's name, and that the trust has not been revoked. You will use this for all of your financial transfers. The third thing, and this is what most people are going to mess up, they do not fund their trust. Now, the mistake that most people are going to make is they will create that trust document, print it off, sign it in front of notary witnesses, give it to their successor trustee, but they forget to transfer the assets into that revocable trust. And when this happens, your trust is useless. Your assets are still in your name, so they'll still have to go through the probate process to be distributed out to your family so you you've wasted thousands of dollars. For real estate, you want to make sure you're using a quitclaim deed or a warranty deed to transfer that property out of your name into the name of the trust so that the trust actually owns that property. For banks and brokerage accounts, you just want to retitle those accounts into the name of the trust. And then for life insurance and retirement accounts, if you want to, you can name that revocable trust as the designated beneficiary on those accounts. That way, when you pass away, that money will dump into that revocable trust, and then that trustee can control the distribution of that money out to the beneficiaries. Okay, we've covered the three main things that you need to be aware of when you set up your revocable trust, but you need to make sure you don't miss this one last step. You cannot be commingling money, so you have to keep your accounts and the trust account separate. If you mix personal funds and trust funds, the judge could deem that you have broken your fiduciary duty and makes your trust worthless. Also, you don't have to worry about filing separate taxes for the assets inside of your revocable trust because you will still file those assets on your personal tax return using your social security number. The IRS is just going to treat the assets as if they are yours, even though the trust owns those assets, which is what makes them avoid the probate process when you pass away. Don't let simple mistakes mess up your revocable trust, forcing your assets to have to go through the probate process, meaning that your family will likely have to hire a probate attorney for $10,000 to $15,000, and all of your assets and who they are going to will be public information for everyone to see. If you want help setting up a revocable trust, click the link in the bio, fill out the form, and schedule a time to talk to someone on our team.